Mr. Haddad?
Yes.
Hi there, good morning. I appreciate you zooming in. I just wanted the prosecutor to be able to look at your motion, your request to travel on behalf of your client.
Yes, she signed off on it.
Okay.
That's what I'm saying. Like, I waited so long to.
Yeah, electronically she signed off on it?
No,
Yes, ma'am. I believe I sent that in a back to Mr. Haddad with my signature.
Okay. Well, I'm glad that you came here because it is, a lot of times we get orders back, proposed orders back that look just like that, and the prosecution has no idea what it is.
Oh, I forwarded the chain link email with her. I always forward the chain link email with those.
I appreciate that. It was just handed to me by Mr. Clerk. So I'm the type of person that likes to cross my T's and dot my I's. Please forgive me if it's inconveniencing you.
Okay. Calling parties on Eugene Archer. Calling case number 20-61175, People versus Eugene Blake Archer. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, assault or assault battery. Defendant is a habitual offender. Third offense notice. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Remax Proof on behalf of the people.
Elliot Margolis, Your Honor, P28078 on behalf of the defendant.
Okay, good morning to you. Your client?
My client, I was unable to get in touch with. I wrote him a letter immediately after we were in court Wednesday. I've received no reply, and I've been unable to reach him by phone.
Thank you. Is there a motion?
Your Honor, people move for a capias.
Thank you. Yes, this matter was, for refreshing my memory, this matter was set for an exam on the 21st. The defendant failed to appear, and Mr. Margolis zoomed in subsequent to that, indicated that he had not realized it was up for an exam. So we set this for a PCC today in the hopes that perhaps we could get everybody on the same page, with there being no indication that Mr. Archer has had any confusion about the date, and Mr. Margolis has indicated he's had no contact with his client. I am going to grant that motion for capias. The previous bond is going to be revoked, and new bond is going to be set at $10,000 cash or surety.
Thank you, Judge.
Thank you. Take care.
Bye-bye. You too.
Thanks.
Calling parties on Sylvia Glenn. Calling case number 20-60297, People versus Sylvia Latrice Glenn. Defendant is charged with 1 count, home invasion, first degree. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Remax Proof on behalf of the people.
Good morning, Your Honor. May it please this court, Anthony Lewis on the there's something wrong with my camera, Judge, so I hope you can still hear me.
Well, your audio is dipping. If you could just repeat what you just said, sorry.
Okay. Good morning. May it please this court, Anthony Lewis on behalf of Miss Glenn, P numbers 43876. Miss Glenn is on with us, Judge, and she can state her name. Miss Glenn, state your name for the record.
Sylvia Glenn.
What's your pleasure, counsel?
Judge, the court had set this for today because when we were last in court, my client was not present, and we did not have complete discovery, and the court had instructed myself and the prosecutor and the detective when we were last physically in court to discuss this off the record. We did in fact do that. I gave them all the details as to what my client informed me that happened so that I could get complete discovery. I have yet to receive the discovery that is out there. I know the prosecutor told me that the 911 recording would probably not be available because the case did not get processed until after the time limitation for the 911 recording to have been expired. But there should still be the police run sheet. There should still be a police incident reports, and I don't know what else there would be.
Thank you. So is there an additional discovery we can get to Mr. Lewis?
Your Honor, I have no idea. I don't even have a file on this. I'm not sure which prosecutor he spoke to. Bryn, if you're here, can you chime in if it's you that he's referring to?
It was me. The detective and I did make inquiries and did look. There's not even a run sheet.
Can you put your appearance on, please, and thank you?
Yes, ma'am. Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Okay, so if there's nothing else outstanding in terms of discovery that needs to be turned over based on that representation, Mr. Lewis, what is your pleasure here today? Would you like to set it for an exam or something else?
Yes, Judge, we would need to set this for exam.
Okay, in person, I'm assuming?
That would be in person, Judge, yes.
Thank you. Mr. Clerk?
Yes, ma'am.
And Judge, before the detective that the prosecutor spoke with, I would ask the court to have him to come to court and to swear to that there is no findings, because my client informed me that she called and she spoke with dispatch. Dispatch had instructed her that they had already sent out a car. She requested another police car and more police came. 2 police talked with her and 2 police talked with her boyfriend. So
Okay, so Mr. Lewis, certainly you have subpoena. Make sure that you exercise those and so that they can be present at the exam date. In-person exam?
Yes, Judge, but
Oh, yes?
I do not know who the prosecutor is speaking of that she has relayed this information to the court.
We can remedy that real quick. Ms. Bailey,
Oh.
who is it that you're referring to?
Your Honor, I don't have the file in front of me. I don't recall. I think it's Detective Gambrel, but her name is certainly all over the discovery.
Oh, it's then, Judge, if it's the detective that was physically there on the 25th of June, that's
So
fine.
listen, this examination date is going to be in December. There's going to be lots of time for you to have a conversation with Ms. Bailey off the record and ensure that that is actually the officer, the officer in charge or the detective that you're looking for. And in the event that it is, please exercise your subpoena powers if you would like for that officer to be present at the examination date. Mr. Clerk?
Oh, okay.
December 20th at 11:30.
December 20th at 11:30 is going to be the examination date in person. In the event that you're finding that there's some issue regarding discovery, you again are going to have plenty of time to tee this up for a motion hearing in that regard. If you have some continuing issue regarding discovery, okay?
Yes, Judge.
Next case.
Calling parties on Antonio Robinson. Calling case number 2059821, People versus Antonio Demetrius Robinson. Defendant is charged with 1 count, aggravated stalking. Also calling case number 2060015, People versus Antonio Demetrius Robinson. Defendant is charged with 1 count, aggravated stalking. Defendant is scheduled today for examinations on both matters.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Bloomers, P77307 on behalf of the people.
Good morning, Judge. Christopher Quinn, P69483, appearing on behalf of Mr. Robinson.
And your,
I had submitted a stipulated order to adjourn today because I'm out of town. So I was going to give, I was going to give my client a new date. I didn't, but I have been in contact with him, Judge.
wait, I'm sorry. Is Mr. Robinson here?
No, he's not, Judge.
Oh. Wait,
I have been
I'm
in
sorry.
contact.
Distracted. I'm writing on the previous case when you were talking. Why is Robinson not, this was scheduled for an in-person exam. I understand you said you're out of town, I think, but why is Robinson not either present in person or on Zoom?
Well, I was going to, he was aware, but I was going to give him the new date. If the court was inclined to give a new date, I can call Mr. Robinson and see if he's able to Zoom in.
Judge,
Oh, I may have missed something. Did you already let the prosecutor know you?
Yeah, I submitted a stipulated order on, I believe, Tuesday or Wednesday to the court.
Okay, that's what I was asking you. Okay, Mr. Bloomers.
yeah, that's all I wanted to say, Judge, is that Mr. Quinn noticed me at the time and I told him I stipulate.
Okay, your audio's dipping out, but I'm assuming you're saying that you agreed to stipulate to the adjournment, correct? Yes?
Yes.
Okay, that being said,
Yes.
we are going for a new in-person examination date on both of these files. Due to the nature of the allegations, are there concerns regarding bond?
No, Judge.
Mr. Clerk, can we have a date? Can we have a date? Really the next available date. If there's no concern regarding bond, can you assign a date, please?
Also,
Whatever you see is available.
oh,
I mean, I know that we're stacked, but
okay. A December date? Did you say a December date?
is that what, okay, so
Will be December 20th at, so we just did 11:30? Well, December 21st at 9.
December 21st at 9?
Sounds good, Judge.
Okay, anything further?
No, Judge.
Okay, thank you.
Thank you. Have a good day.
You too.
Judge, can I check in on a case of Dominic Meeks?
Sure.
I have to check.
Thank you.
I checked it in. I saw his name. His
Okay.
message in the chat. Calling parties on Eugene Hubbard. Calling case number 2159013, People versus Eugene Hubbard. Defendant is charged with count 1, homicide, murder, first degree, premeditated. Counts 2, 3, and 4, assault with intent to murder. Count 5, weapons, firearms, discharge from a vehicle causing death. Count 6, weapons, firearms, discharge from a vehicle causing injury. Count 7 and 8, weapons, firearms, discharge from a vehicle. Counts 9 through 16, weapons, felony, firearms. Defendant is scheduled today for a motion hearing.
Thank you. Appearances, please.
Lord, Your Honor, Matthew Makepeace on behalf of the people, P82796.
Good morning, Your Honor. Patrick Nineheist, P76343 on behalf of Mr. Eugene Hubbard, who is in the Wayne County Jail, and I would ask to waive his presence
No objection.
And I'm just going to withdraw the motion, Judge. Mr. Makepeace has given me all the discovery.
Perfect. Okay, his presence will be waived, your client's presence, that is, for purposes of the hearing today.
Hey, let's speak to Mr. Jamil Kuja. Yeah, just tell him, Patrick.
And the motion is withdrawn. Anything further?
No, Judge, I just wanted to say thank you to Mr. Makepeace for being so accommodating and getting me the discovery as soon as possible. And thank you for your clerk in court for putting this on the docket today.
Thank you.
Thank you, Judge. We have an exam date August 11th on this case. See you then.
Thank you, Judge, and it's a 3-day exam.
Okay, yes, I do see that. Thank you.
Yep, thank you very much, Judge. Thank you, clerk.
Take care.
You're welcome. Calling parties on Deron Sanders. Calling case number 20-56848. People versus Deron Sanders. Defendant is charged with count 1, armed robbery. Defendant is scheduled today for a competency hearing.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Fuka on behalf of the people.
Ms. Officer. Is she in?
I'm here.
Calling parties on Dominique Meeks. Calling case number 21-59560. People versus Dominique Marcus Meeks. Defendant is charged with count 1, controlled substance, possession of cocaine, heroin, or another narcotic less than 25 grams. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor.
Morning.
Rima on behalf of the people.
Good morning, Your Honor. Patrick McQueenie, P45797 on behalf of Dominic Meeks. Judge has just retained on Tuesday evening. We're looking to adjourn the probable cause conference seeking discovery.
Okay, so today is the 23rd. How about August 23rd via Zoom?
That's fine, Judge.
Okay, I do find good cause to adjourn so that you can not only receive the discovery, but also review it with your client. Is your client here?
He is, Judge. He's on mute. He's muted.
Okay, can you unmute and state your name?
Dominique Marcus Meeks.
Thank you. Okay, August 23rd at 8:30 via Zoom, new PCC. Anything further?
No, Judge. Thank you very much.
You're welcome.
Have a good day.
You too.
Calling parties on Will Morris. Calling case number 21-59355. People versus Will S. Morris. Defendant is charged with count 1, assault with intent to do great bodily harm, less than murder by strangulation. Count 2, domestic violence. Third offense notice. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
May it please the court, Your Honor, Tyrone Baker appearing on behalf of Mr. Will Morris, who's present via Zoom, P number 62647. Good morning.
Good morning. Can you give me another case?
Calling parties on Kenyatta Wesley. Calling case number 21-55447. People versus Kenyatta Wesley. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Defendant is scheduled today for an examination.
Thank you. Appearances, please, starting with the prosecution. I need another case. general warrants maybe.
That's all that I have that's ready.
Okay. P, you want to take a break? There's nothing ready to call.
Yeah, everybody else left.
Your Honor, Attorney Kiana Franulik, P73015, on behalf of Ms. Leslie. I had logged in. I know we're set for 9:30. Hoping to see if the people were ready to proceed before I actually, entered the building. Came in.
Who's the corresponding prosecutor?
Your Honor, unfortunately, it changes a couple of times, but because it's a DV case, I'm not sure if it's still Mr. Bloomers or if someone else has taken over.
Okay, can you give us just a moment because Mr. Bloomers is probably walking over?
Absolutely. And again, I don't know, has the complaining witness checked in?
I don't know. Officer, do we have a witness that's checked in on Wesley?
No, you aren't.
Not yet. And I don't know if Bloomers is not in here right now, so anybody that's waiting in Zoom, we can't call cases until we have the opposing counsel. So bear with us. We're gonna stand in recess until we've got prosecutors to call that correspond with the cases.
All right, thank you, Your Honor. I'll just go on mute and head that way.
As soon as he comes back in or comes into Zoom gallery, we'll address that matter, okay?
All right, thank you, Your Honor.
Welcome.
Good morning, Mr. Clerk. This is APA Jacob Slusky. I was just hoping to see if new dates were given out on 2 PCCs I have this morning.
Can you give just 1 second, please?
Of course.
Thank you.
Calling parties on Tanisha Lindsay. Calling case number 20-60431, People versus Tanisha Renee Lindsay. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Hoopi on behalf of the people.
Good morning, Your Honor. Sharon Payne, P38749, representing the defendant, Tanisha Lindsay.
Thank you. And Ms. Lindsay.
Your Honor, I have made numerous attempts to contact my client. I have sent letters. I have made phone calls to the only number that I have, and I have engaged the services of an investigator, and I was unable to find my client or make contact with her.
Okay, with today being the date and time set for a preliminary examination, it is unfortunate that she did not join the party here today. Is there a motion?
People move for cases, Your Honor.
It is currently 9:27. This matter was set for 9 a.m. examination, and not hearing any reason that would explain why Ms. Lindsay is not present here today, I am going to grant that motion for a caveus to issue. The previous bond is going to be revoked. New bond is going to be set at $10,000 cash as surety. Is there anything further?
Nothing further, Your Honor.
Nothing from defense, Your Honor. I will attempt to keep contacting my client.
Okay, thank you so much. All right, we're all set here.
Your Honor, can you ask who we have from, Wayne County Division 1 for A4?
Who do we have, Wayne County Division, I see 2. State your names, please. Division 1. They're Division A4. Yes. Cantonary.
That's not. Can you ask something to get the deputy so I can get some information from him?
Mr. Cantonary, can you please tap the deputy and have him come?
Good morning, Judge.
Good morning to you. I actually need the deputy, or maybe you can help me.
We're all in the same room.
Okay, thank you so much. Mr. Clerk?
Yes, can you, Mr. Cantinelli is not on our docket today. Can you spell his last name for me?
On our docket is spelled CANTINERI. First name of Anthony.
Mr. Bloomers?
What's his date of birth, deputy?
Give me 1 second. He's on ours for a tether violation. I'll pull up his date of birth in 1 moment.
Okay.
His date of birth is March 5th, 1978.
Okay. I got one more question.
Okay.
What case do you have him for being on violation of the tether?
Okay, give me 1 moment. Sorry.
He has a few cases in the system.
I have that medical record request I need to sign.
Oh, sure, you can hand it to Mr. Clerk.
Come on.
Thank you, sir. Good morning to you. Officers, Mr. Bloomers out there?
He is. I did see him come in and walk right back out. Here he is.
Mr. Bloomers, Ms. Franulik was inquiring about Kenyatta Wesley, if you have witnesses.
Well, let me ask her to check in.
My client is present in the building, Your Honor.
Okay.
Well, you can call it whenever the court is ready, then.
Okay, all right. Officer, can I trouble you to have Mr. Wesley or Miss Wesley on the, Miss Wesley enter? Did the officer hear me? I don't know. Can I trouble you? I don't think he heard me.
Yeah, he went to get her.
Oh, okay.
I'm just gonna call him all once for proprietary.
Deputy at Division 1. It looks like Mr. Cantinelli needs to be in front of Judge Jefferson today.
Okay, do you still want this case number that I have?
I see several case numbers, so let's see. Hold on, give me 1 second.
Yes.
Can I tell you to hand me the Wesley file?
Oh, I can call him back. Give me 1 second, Deputy. Calling parties on Kenyatta Wesley. Recalling case number 21-55447. People versus Kenyatta Wesley. Defendant is charged of 1 count, assault with a dangerous weapon, felonious assault. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
And good morning, Your Honor. Attorney Kiana Franulik, P73015, appearing on behalf of Ms. Kenyatta Wesley, who is also present in the courtroom for today's date.
Thank you. Could you please state your name? Kenyatta Wesley. Thank you. Today is the date and time set for preliminary examination. Are we proceeding to say?
Your Honor, at this time, the complaining witness, Samuel Scarborough, is not present in the courthouse. He was keen to be here for a 9:30 a.m. preliminary exam. Without his presence participation, the people are unable to go forward this time.
Thank you. Is there a motion?
Your Honor, I will move to dismiss this matter.
It is currently 9:33. Matter was set for 9:30, and the complaining witness has failed to appear. As such, I am going to grant that motion. Keep in mind that the matter is dismissed without prejudice, which means it is possible that the prosecution can reissue. If you have questions about that, please make sure you ask your attorney to explain it to you in greater detail. Do you have on a GPS tether?
No, ma'am.
Ms. Ranulik, do I have permission to sign your name to the order of dismissal as the moving party?
You do, Your Honor.
Okay, we're gonna make sure we get a copy of this dismissal to both you and the prosecution, and once it's been processed. Anything further?
Nothing further, Your Honor.
Thank you so much.
Thank you. Everyone have a safe day.
You too. Have a good weekend.
Deputy, I have a case number for Mr. Cataneri.
Okay,
It's 2005
okay.
75 3301. And I stand corrected. That's Judge Bryant this morning.
Okay, and I have one question. He has a case number of 219-060-958-01-FY, in which he just violated on the 20th. I think that's a Judge Archer's case for tether violation. You all have that report?
Deputy, can you call the courtroom and I can talk to you over the phone?
Yes,
We
sir.
can continue.
Yes.
It's 965-2282. Calling parties on Will Morris. Calling case number 21-59355, People versus Will S. Morris. Defendant is charged with count 1, assault with intent to do great bodily harm, less than murder by strangulation. Count 2, domestic violence, third offense notice. Defendant is scheduled today for a probable cause conference.
Thank you. Please.
Jacob Bloomers on behalf of the people.
May it please the court, Your Honor, Tyrone Bickert appearing on behalf of Mr. Will Morris, who's present via Zoom, Your Honor. Good morning.
Morning. Please state your name, Mr. Morris.
Will Morris.
Thank you. It is the date and time set for a PCC. What's your pleasure?
Your Honor, I am in receipt of the paper discovery in this case. Your Honor, I am respectfully requesting an exam in this matter. I would ask the court to set it at the earliest possible date. This is a, I guess what could it be in common terms be referred to as a he said, she said type of case.
Okay. Are there any concerns, Mr. Bloomers, regarding the bond that might affect the timing of this?
I'm sorry, defendant in custody.
Is the defendant in or out?
He's in custody, Your Honor.
Okay.
Yeah, my only concern, Your Honor, is that I don't see a tether condition that was imposed, and so I would ask that the bond be modified to add the GPS tether condition, but otherwise people are satisfied.
Okay, are you picking up? Hey. 3. Little musical interlude for you. Okay, the bond is currently $15,000, 10%. Mr. Bloomers, what I was asking Mr. Bickert is if you could hear him. He's requesting that a GPS tether condition be added, which of course is usually par for the course on a domestic violence allegation. But before we get there, the defendant is in custody. I did not realize that when he stated his name. So with that being said, can you let us know, Mr. Bickert, what date you would like? Seeing as though he's in,
right,
seeing as though he's in, he has priority.
The only dates, Your Honor, that I would not like is the week.
Tell me what you want. No, tell me what you want.
Oh, I can take any day next week, Your Honor.
Okay, today is the 23rd. More realistically, the week of August 2nd. Let us know.
That's my problem, Your Honor. I'm out that entire week.
Oh, because next week is there's nothing next week. So the week of August 9th. Pick a date.
I'm sorry, Your Honor. Let me just double check so I don't give you a bad date. I'm checking my other phone calendar right here. Your Honor, I'll take the Tuesday.
Okay, let me just ask, Mr. Bloomers, have you been in contact with the complaining witness?
I have not been able to reach the complaining witness at this time. However, the warrant prosecutor was able to contact her. She didn't want to go forward at that time.
Mr. Bickert, pick a day next week. We'll do it next week.
Thank you, Your Honor. I'm sorry. I'm trying to make sure that that's a good date.
The 30th? That would give you 7 days?
Is that Friday?
Yeah.
That would be fine.
Okay. Are you available the 30th? Because that would give it the minimum of 7 days. I can't do it any closer than that.
That'd be fine. That'd be fine.
All right. So in-person examination, July 30th. We'll set that for 10 a.m. Anything that you would like to address? Because the last thing is the additional measure that Mr. Bloomers wanted to add to the bond. Did you wish to be heard on that?
Your Honor, simply, I appreciate the court giving me the date that it gave. I would have no objection to a tether condition. I certainly would ask the court to consider lowering my client's bond given the circumstances. If the court were, I certainly think that with the tether, et cetera, that it would fulfill many of the concerns as far as bond. I would ask the court to consider reducing Mr. Morris's bond.
Well, unfortunately, I don't know those circumstances as you do. So I'm not as intimate with the details in terms of what may be going on behind the scenes. So all I can go on is what I have before me, the allegations and this brief summary of the investigator's report. And given what I have before me, there's nothing that would lead me to believe that the bond that was set by the magistrate was inappropriate, the monetary bond. However, I do agree with Mr. Bloomers, given the nature of the allegations, a GPS tether is appropriate so that we can maintain confidence that there will be no contact between the defendant and the complaining witness. So I am going to add that. I'm going to deny the motion to lower the bond. I'm going to add the requirement of a GPS tether in the event that he is able to post that 15,000, 10%. And our examination is July 30th at 10 a.m. We will see you then.
All right, thank you, Your Honor.
A bond form.
A bond reduction order.
Well, I'm going to cross out word reduction, but that's the form I need.
Okay. Or do you want this one?
Because that's less writing on this one. Yes. Mr. Bloomers, I do need your signature on this motion to amend bond.
Calling parties on Rolando Maldonado. This is the
Ready.
calling case number 21-59406. People versus Ronaldo Maldonado. Charge account 1.
Please keep your devices muted. Go ahead.
Defendant is charged with count 1, home invasion, first degree. Counts 2 and 3, criminal sexual conduct, second degree. Count 4, 5, count 4 and 5, criminal sexual conduct, fourth degree. Count 6, domestic violence. Count 7, malicious destruction of personal property less than $200. Defendant is scheduled today for a probable cause count.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggins, P82125, on behalf of Mr. Ronaldo Maldonado.
Madam Interpreter,
Good morning, Your Honor.
could you state your name, please?
Evelyn Villarreal, State Certified Court Interpreter.
And could you spell your first and last name?
Yes, Your Honor. Evelyn is Evelyn. Villarreal is V as in Victor, I, 2 L's, A, 2 R's, U, E, L.
Thank you. Please raise your right hand. Do you solemnly swear or affirm to translate accurately from English to Spanish, Spanish to English to the best of your ability?
Yes, I do.
Thank you so much. Mr. Maldonado, please state your name.
Señor Maldonado, por favor, diga su nombre.
Rolando Maldonado.
Rolando Maldonado.
Counsel, what's your pleasure?
Licenciado, ¿qué quiere usted hacer?
Your Honor, I have received paper discovery. I do not know if there's any video discovery. If there is, I would like that to be sent. At this point, I'd like to...
Oh, excuse me. Su señora, yo he recibido las pruebas que son en documentos. Si hay alguna prueba por video, todavía no la he recibido y me gustaría recibirla.
Your Honor, I'd like to schedule a preliminary examination. Obviously, there are some impediments to this.
Su señoría, me gustaría fijar una fecha para una audiencia preliminar. Claro, hay ciertos impedimentos con esto.
So I'd like to set it at least a few weeks back to be able to adequately discuss this matter with my clients.
Así que me gustaría pedir una fecha ya en unas cuantas semanas para poder hablar con mi cliente con respecto a su caso.
Would you like to set it the week of August 16th or the week of August 23rd?
¿Le gustaría a usted para la semana del 16 de agosto o para la semana del 23 de agosto?
I can try for the week of August 16th.
Puedo tratar de estar disponible para la semana del 16 de agosto. Bien.
What date?
¿Qué fecha?
I am free August 17th.
Estoy disponible el 17 de agosto.
August 17th it is, at 10 a.m.
Así que vamos a fijar la fecha el 17 de agosto a las 10 de la mañana.
And Your Honor, is it possible to schedule a bond hearing for next week and order a DSU?
Sure.
Y su señoría, ¿sería posible fijar una fecha para tener una audiencia para ver si podemos conseguir una fianza? Sí.
Because my client does not speak English, I have not had an opportunity to discuss where he would stay if he were released. So I'd like to, now that I have an interpreter, be able to discuss his case and where he would stay with him.
Y debido a que mi cliente habla en español, no he podido hablar con él para averiguar dónde él se quedaría si es liberado. Así que me gustaría tiempo para poder con intérprete hablar con él.
We can set this for, I think typically they'll need at least a week to turn around a DSU request. My only concern is in the past when we've made DSU referrals, if there is not an interpreter that is going to be available at the time of the interview, it won't be accomplished.
Y se tardan por lo menos una semana para poder fijar una cita con usted y su cliente por el departamento de DSU. Y el problema es que si no hay un intérprete disponible, no van a permitir que se lleve a cabo la entrevista.
I am not sure how to accommodate them on that. If the interpreter, I don't think I have the ability to loan out my interpreter. So I'm not sure how to accommodate them.
No estoy segura cómo esto va a funcionar y no sé si yo tengo permiso de prestarles mi intérprete.
I am not sure as well. I am going to make the note, as I have at every hearing, that a Spanish interpreter is needed. Again, yes. I've been in this before, and we generally will get a report back saying that they were unable to accomplish the interview. But let's try for it. I'm going to make the notation again, and we'll try for July 30th at 8:30.
Okay.
Bueno, yo voy a hacer una anotación aquí que se necesita tener un intérprete de español, como yo siempre indico. Vamos a tratar de ver si se puede lograr para el 30 de julio a las 8:30.
Okay, July 30th bond hearing.
Your Honor,
Así
is it
que el
possible
30 de
to go
julio
in
la
a
audiencia
breakout
para
room?
pedir fianza. ¿Su señor nos permite pasar una sala privada de consulta?
Yes.
Sí.
If it's possible, I'd like to have a breakout room with my client and this Del Real.
Yeah. Yes,
Thank
that's what I was saying.
Y si si sería posible ahora pasarnos una sala de consulta con la señora Villarruel y mi cliente. Sí, eso es lo que yo iba a decir.
Mr. Arnett.
I don't know if he's this as the breakout that I just created, but Deputy, if you can hear us, can you accommodate us by putting Mr. Arnett before the camera? Can you please call another case while they're trying to do that?
Okay. Calling parties on Aaron Davis. Calling case number 21-55801, People versus Aaron Edward Davis. Defendant is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm, less than murder or by strangulation. Counts 3 and 4, weapons, felony, firearms. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Lloyd Morales Smith for the people, P83353.
Your Honor, may it please this honorable court, Larry Pope, on behalf of Mr. Davis, I'm standing for the attorney of record, Lillian Diallo.
Okay, and Mr. Davis. Please state your name. Mr. Davis? Is this an in-person exam? Oh, Mr. Davis, state your name.
This is Aaron Davis. This is Alfana Davis.
Okay, thank you. I need Mr. Aaron Davis. Each state their name. Can I trouble, we don't have an officer. We're gonna have to pass on it, I'm sorry. I don't know what's going on, if anyone else does. We're gonna pass on it, thank you. Next case.
Okay, is Ms. Longstreet back?
Miss, are you there?
Yes, Your Honor.
Okay. Calling parties on Deron Sanders. Recalling case number 20-56848, People versus Deron Jamal Sanders. Defendant is charged with count 1, armed robbery. Defendant is scheduled today for a competency hearing.
Thank you, sir. Please.
Good morning, Your Honor. Remash Blue Family Acting People.
Good morning, Christine Longstreet from the Neighborhood Defender Service, appearing on behalf of Mr. Saunders.
Is Mr. Saunders here?
He is, Your Honor.
Okay, please state your name.
Deron Jamal Sanders.
Morning. Okay, this is a competency review date. Do we have a new evaluation back?
So, Judge, we did receive an evaluation. They indicate that Mr. Saunders is incompetent and they recommend a placement. I have been speaking with Mr. Saunders, and as you can imagine, that has created some very severe stressors. The thought that he would have to be placed in custody and confinement and possibly potentially force medicated. I would ask the court to give me about 3 or 4 weeks to see what our options are, to see, I really, this is a not typical situation. I mean, I know that it has happened before, because one of the things that the writer of the report, Mr. Saunders, can you please mute your microphone? One of the things that the writers of the report indicate is that Mr. Saunders understands the nature and purpose, but focus and being able to rationally participate. Someone's talking.
If I could just welcome everyone to the Zoom gallery. If you're new to Zoom court, I'm gonna just ask kindly that you familiarize yourself with your own device such that you know how to mute your microphone. It looks like a little microphone. You just tap on it. And then when you need to speak, you can actually unmute your own self. But while the court is in session, I need everyone to keep their microphone muted because we have a difficult time hearing from our perspective. The next thing is that if your case is being called, my expectation is that your video is going to be rolling. Again, familiarize yourself with your device to the extent that you can get your video up and running. Now, the next thing is that this is court. It may not seem like it, but this is a courtroom. I need you to come to court properly dressed and actually wearing clothes. Wearing clothes, and that's one of the things. Joseph, who's left the video there, please make sure you put a shirt on. And that you would not use any profanity and generally act in a fashion that you would if you were actually inside of a courtroom. Joseph, please put some clothes on, sir.
Yes, okay.
Thank you so much. So with that being said, Ms. Longstreet, I will ask you to repeat some of what you said because Madam Court Reporter could not get the fullness of what you were saying.
So Judge, what I was asking and requesting, because two things, the statute does allow for treatment outside of the forensic center. I just need to really explore possibly other options that could help get Mr. Saunders to competency. One of the things that the writer of the report does say is that he does understand the nature and purpose, but he has a hard time staying on track and task and communicating effectively. So so although clearly I'm not a forensic psychologist, I just want maybe 3 weeks to see what our options are outside of a placement at the forensic center where Mr. Saunders will be confined and potentially forcibly medicated. He is been on bond all this time, and he does have 3 small children that he indicates that he provides care for.
Okay. Now, what's interesting is that I don't have a copy of that report in my file. Madam Prosecutor, and I guess I should ask as a matter of formality, are you stipulating to the findings of that evaluation?
Judge, I don't want to do that just yet because it may be a situation where this sounds sort of counterintuitive, where we get another opinion.
So independent evaluation.
Right. And so I just...
If your desire is to have him independently evaluated, I'll adjourn it. But okay. I don't necessarily want to adjourn without some sort of movement being made. I want to understand. I hear what you're saying and I hear your concerns, but I think that there either needs to be a stipulation to the findings or your desire to have an independent evaluation.
Well, Judge, then that's the request I'll make, that we get an independent evaluation.
Okay. As I look, I understand he's been out on bond, but this is a very serious allegation, armed robbery.
Yes, Your Honor. We do understand that this is a serious allegation. I don't believe that, Mr. Saunders, I don't believe there have been any violations as relates to his bond.
Ray, can you please mute your microphone? That'd be great. Okay, this is what I'm going to do. If you find yourself suddenly in a different room, don't worry, we'll bring you back. I'm gonna put everyone in waiting room. Okay, Ms. Longstreet, so what time frame would you like to adjourn this so that you can explore this independent evaluation?
I think if the court would give us 4 weeks, if once I reach out to the psychologist, if he thinks he needs more time to accomplish it, then I will alert the court.
Okay, so today is the 23rd, August, we'll say August 27th. We'll circle back on this issue. I'm making a notation that an independent evaluation will be sought by the defense. Is there anything further?
No, Your Honor.
Thank you so much. Can you call another case?
Calling parties.
Thank you.
Calling parties on Irma Dixon. Calling case number 2060174. People versus Irma Kimberly Dixon. Defendant is charged with count 1, operating while intoxicated, causing death. Count 2, moving violation, causing death. Defendant is scheduled today for a motion hearing.
Thank you. Appearances, please.
Good morning, Your Honor. Jonathan Mysick, P74620 on behalf of the people. And I see Ms. Silver is here, but she is muted and her camera's off.
Sorry, I'm here. Sorry. Here I am.
What is your pleasure here? Oh, can you
Judge,
put
I
your
understand my client is in the courtroom. Today was a bond review. I received a text message saying that she actually appeared in court. I think our exam is scheduled in a month or so, 2 months from now. But this was scheduled for today for a bond review.
Can you put your appearance on, please?
Oh yeah, sorry. Gabi Silver appearing on behalf of Irma Dixon.
Okay. Ms. Dixon, if you're connected to audio, can you please unmute and state your name?
I believe she's in the courthouse, Judge.
Oh, okay.
Your courtroom prosecutor texted me and told me that Miss Dixon had appeared in person.
She's leaning into the camera here, but either way, if you want to bring her in, if she wants to appear via Zoom from the hallway, I'm here for it. Ms. Dixon, if you can hear us, please state your name. Okay, do we have another case we can call?
Can you ask who do we have sitting at Wayne County Jail?
Who do we have in Wayne County Jail? And Mr. Wallace is raising his hand that he's ready.
Yeah, we can call Willis now.
Your Honor, before you go on to another case, I just need to, that I have an in-person exam before Your Honor at 11 o'clock, and my witnesses are starting to arrive at 10:30, so I need to start walking over to the courthouse.
I'm gonna call it right after this. I think they went to get her from the hallway.
All right, I'll stand by.
This is Ms. Dixon.
Okay, hold on. Please call Mr. Wallace's case.
Willis, okay.
Hello?
Please give us a moment. Thank you so much.
Calling case number 21-56087, People versus Victoria Shanae Willis. Defendant is charged with count 1, assault with a dangerous weapon.
Hold on.
Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Ted Wallace on behalf of Ms. Willis, who is present in court. She stands behind me to my right.
Thank you. Please state your name. Thank you. Today is the date and time set for a preliminary examination. Are we proceeding to an exam?
Your Honor, at this time, the complaining witness, Trinice Ford, is not in the courthouse. She was subpoenaed to be here for a 10 a.m. preliminary exam. Without the presence participation, people are unable to go forward at this time.
Is there a motion?
The defense moves to dismiss, Your Honor.
Okay, it is currently 10:04. This matter was set for 10 a.m. And with those representations being made by the prosecution, I am going to grant that motion to dismiss this matter without prejudice, which means that language that follows the word dismissal without prejudice means that it is possible that this can be reissued. If you have questions, which I would imagine would, about why and the how of that, please make sure you speak with your attorney and he will explain it to you in greater detail. Do you have on a GPS tether that needs to be removed?
No, ma'am.
Okay. Counsel, I just need your signature on this order of dismissal as the moving party that I'm preparing right now. Is there anything further?
Nothing from the defense, Your
Nothing
Honor.
from the people, Judge.
Okay, all set for Mr. Watts. Was Irma Dixon in the hallway?
She had never before. I don't know where she went. She wasn't. 8092.
Left the floor, they said.
But she was trying to zoom in. I heard her trying to say her name earlier. It was cut out, but I did hear her trying to zoom in.
Ms. Irma Dixon, can you hear us?
Judge, I'm happy to waive her appearance for this.
Hello?
Oh, I hear her. Miss Dixon, is that you?
Yes, it is.
Okay, I don't see her, but I hear her.
Yeah, my phone was at 2% and the security got me a charger. So, and I've been up there since like 8 o'clock waiting.
We're gonna call it in just a moment. They're bringing her into the courtroom.
Your Honor, do we know if that's Mr. Arnett in the county jail? He's raising his hand. He may be nodding. If he's nodding, that's Mr. Arnett. If we could save ourselves some time, if I could get a breakout room with him, although it looks like he's in a wide open room with very little privacy. So I don't know how much I can talk to him. I'm not going to talk to him in this room if there's no privacy.
Cut that out. Okay. Cut it off? Yeah, I'm taking it.
I'm surprised.
Mr. Misick, as soon as
Here she is,
here she is. People versus Irma Dixon. This case was already called 200-60174. Appearances again, please.
Good morning, Your Honor. Jonathan Mysick, P74620 on behalf of the people.
And good morning, Your Honor. Gabi Silver, appearing on behalf of Irma Dixon. My bar number is 36382.
Please state your name.
Irma Dixon.
Thank you. Okay, today is a bond motion date that was set, I believe.
Judge, if I could just quickly remind the court of what was going on with this case. Ms. Dixon was charged back in September of 2020. And of course, since through no fault of anyone's, we have not had an exam date yet. The court was shut down for a period of time, we know. And at some point, there were some witnesses that were not available for Mr. Mysick, and it got adjourned. In any event, the last time we were before the court, when the newest date got set, you had indicated that we could come in today to again address the issue of bond. Ms. Dixon has been on bond since September of 2020. This court put her on a tether bond with, I think, remind me, Mr. Mysick, what the bond was at I don't think it's SoberLink.
No, my notes indicate that there was an alcohol tether with a $70,000 10% bond.
Correct. So that alcohol tether was put on after she had been on bond for, about 6 months without incident. So now she has been on the alcohol tether for a significant amount of time, again, without incident. The court told us that you would take another look at it after she had been on the alcohol tether for more time to see if there had been any violations. I have not been apprised that there have been any violations. Ms. Dixon continues to be compliant. She works full-time, and we're asking the court to reconsider the bond conditions.
And Your Honor, yes, Your Honor, I can also indicate that I've inquired about any issues with the bond, with the tether, and I have not learned of any problems, hiccups, or any kind of violations.
Okay, so while I definitely understand, so she's been on the alcohol tether since March 24th. And I appreciate the fact that there's been no, according to the representation, there's been no violation. I'm not amenable to removing alcohol monitoring. However, I would be open to perhaps, particularly since I'm not hearing any objection from Mr. Mysick whatsoever, I'm open to amending the alcohol monitoring from an alcohol tether to something else like jams. There needs to be some level of alcohol monitoring to ensure that she's not consuming. So again, since Mr. Mysick does not seem to have an objection, I would be willing to amend to something like jams 3 times a week, but not an outright elimination of alcohol monitoring. What are your thoughts on that?
My thoughts are that I think jams is more onerous. I mean, doesn't have the ability to get around and to get to and from jams. And 3 times a week on a random basis without transportation, I think is going to be pretty difficult for Ms. Dixon.
Okay.
Well, again, like the court, Your Honor, given that there have not been any problems, I am amenable, like the court, to amending the alcohol tether provision. However, again, as this court is well aware that that there is an OWI component to this case where it's alleged that the defendant blew a 0.18 and 0.17 on the data master, and so certainly people do have.
That's what I was considering, but it sounds like you're saying you want the alcohol tether removed?
Well, it's not so much that I want the alcohol tether removed. I understand the length of time that the defendant has been on the tether, plus the additional time that the defendant will likely remain on tether. The alcohol issue is a major issue in this case, and so removing the alcohol tether or removing some kind of alcohol monitoring is certainly not something that people are inclined to do. But as I said, amending alcohol monitoring to something less onerous than the tether would certainly be, I think, appropriate.
Okay, so I guess I'm confused. Been on the tether for 3 months. She has not been on the tether since 2020, since September of 2020. I want to be clear on that. The second thing is, I'm sure you're giving me conflicting posture. I'm not really sure, so I have to go with what I believe is appropriate here. This is an OUIL causing death. 0.18, 0.17, yes, I did review that. And that's precisely why I'm taking the stance that I did. This was not something that was imposed by the arraigning magistrate, which I found to be troubling, that there was not an alcohol monitoring provision attached to this. There is an individual that did not make it home that day. And until this is cashed out, I am not comfortable, while this is pending, and this is under the umbrella of this court, I am not comfortable eliminating the alcohol tether, notwithstanding what I'm kind of hearing, kind of not hearing from the prosecution.
Well, ultimately, Judge, I think I respectfully disagree with the court that my position is not conflicting. My initial statement was that I was able to ultimately confirm what Madam Defense Counsel indicated about the lack of any violation of the tether provisions. Ultimately, I think, and so that was just a mere statement of fact. As far as the people's position, I would agree that given the facts alleged in this case, that alcohol monitoring is appropriate, and but balancing that against the last time, the lack of any issues with the tether, again, an amending of the monitoring could very well be appropriate. However, ultimately that's your call. However, Judge, again, as I indicated, that a wholesale removal of the alcohol monitoring would be inappropriate. So I apologize if there was confusion. I hope that I've cleared that up.
I understood Mr. Misek, as well as the court judge. What I'd like to do is ask the court to give us an opportunity to see if I can come up with something that would satisfy the court and Mr. Misek, and perhaps be a little bit less onerous for Ms. Dixon. So let me have a couple of weeks to do that. And if necessary, I will contact your clerk and ask that this matter be put back on the docket.
Yes, I'm comfortable with that. I think that that's because my knee-jerk reaction was to suggest jams, but individual that is can't get to these random testing easily, that could be more difficult than having the alcohol tether. So as long as there's some level of alcohol monitoring, let us know if you've got something you want to run by the court. And if it's as long as there's some level of alcohol monitoring, I'm comfortable with that. And I'll wait for you, Madam Defense, to tee this up for a bond motion hearing if that is the case. Is that okay? Or
okay, Judge, thank you. Miss Dixon, please call me. I've got to run. Thank you.
Okay, thank you.
Thank you, Jonathan. You are.
And Ms. Silver,
really
please let me know if there's anything I can assist with. And I believe that our next court date is a PCC for September the 9th.
Yes, Jonathan. Have a great day.
Thank you.
We have to get through what's here first, so this is something that we can take up at a later time. I don't know.
Calling. Okay.
You know what I'm saying?
Calling parties on Joshua Pittman. Calling case number 21-56273. People versus Joshua Alonzo Pittman. Defendant is charged with counts 1 and 2. Operating while intoxicated, causing serious injury. Counts 3 and 4. failure to stop at the scene of an accident resulting in serious impairment or death. Counts 5 and 6, operating while license suspended, revoked, or denied, causing serious injury. Count 7 and 8, reckless driving, causing serious impairment of a body function. Defendant is a habitual offender. Fourth offense notice, commission of a felony with a motor vehicle advisory. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Akuti on behalf of the people.
Good morning, Your Honor. Sharon Payne, P38749, representing Mr. Joshua Pittman, who is also present in court today.
Thank you. Please state your name.
Joshua Lonzo Pittman.
Thank you.
Your Honor, this is the date and time scheduled for an exam. However, we have been struggling with discovery issues. I received only 2 pages of discovery until yesterday when I was contacted by the prosecutor. At that time, she sent discovery. The paper discovery alone was 56 pages. There are also, in addition to that, medical records, and there are at least 7 body cams. There was no way, Your Honor, I could adequately prepare getting all that discovery less than 24 hours before the exam.
Okay, so are you seeking to have a date? Are you seeking an adjournment?
Yes.
Oh, okay. So, Mr. Clerk, can you find a date that is not too far off, seeing as though this is a reschedule, and it's no fault of defense counsel. She was trying to prepare for this and unable to, due to the discovery being tendered to her in a late fashion. So let's, if we can, Mr. Clerk, can you give us a date, a September date, please? Mr. Pittman, you understand what's going on?
Yes, I do,
Your attorney has the discovery now, but you certainly want her to be able
Yes, I
to
do.
review it so she can intelligently represent you, correct?
And I appreciate it.
So maybe the end of September or the first week in October?
I got September 13th at 9:30.
September 13th at 9:30, Ms. Payne?
That's good for the defense, Your Honor.
Is there any other discovery concerns that you have? Anything else that hasn't been handed over?
I've started working through it, other than not being able to open some of the body cams. I've been in communication with the prosecutor. I think we can work that out.
Okay, perfect. We will see you back then on September 13th. That's going to be another in-person examination date at 9:30 in the morning.
Thank you, Your Honor.
Thank you.
Thank you, Your
Bond will continue. Oh, here's one second. Ms. Sadi, I see that you're in here, but we have to get through this docket first, so if you want to hang out, you can, but we're calling the cases that are up. You can recall them.
I just appreciate your attention. You know, it's been.
You don't have to fully call it, just the case name.
Recalling case number 2159406, People versus Ronaldo Maldonado.
Appearances, please.
Jacob Lucas on behalf of the people.
Good morning, Your Honor. Neighborhood Defender Services by Ken Reagan on behalf of Mr. Ronaldo Maldonado. Your Honor, I've had an opportunity to briefly speak with my client. I don't know if, I think we may have lost our interpreter. At least I don't see her. I've had an opportunity to briefly speak with my client, and my client would like me to make application for bond now, if possible.
I am worried that we don't have the interpreter. Let me see if she's in the waiting room. I don't see her. Yeah, could you give us just one moment, because it is important that Mr. Maldonado understands what's being said.
Sure.
Calling parties on Edward Arnett. Calling case number 2158893, People versus Edward Bruce Arnett. Defendant is charged with count 1, carjacking, count 2, stolen property, receiving and concealing a motor vehicle, second, a subsequent offense notice, count 3, police officer assaulting, resisting, or obstructing. Defendant is a habitual offender, fourth offense notice. Defendant is scheduled today for improbable cause count.
Thank you. Appearances, please.
I believe it's Ms. Bailey's case, isn't it, Judge? Or is it not?
Yeah.
I'm sorry. On Arnett, yes, Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. Arnie Chambers on behalf of Mr. Arnett. Forgive me,
Okay,
Judge, I have two correspondents.
Mr. Arnett, please state your name.
Edward Arnett.
Thank you.
Judge, as this court knows, I was appointed to represent Mr. Arnett yesterday. I was provided discovery by and through evidence.com yesterday. I received paper discovery along with a number of videos. I've been able to review the paper discovery. I would ask if the prosecution could respectfully resend another copy, another scanned copy of that. As the way it's scanned right now, when I print that out, it's going to come out the size of like an index card.
Yeah, I will do that.
Thank you. I appreciate it.
No worries.
In reading the paper discovery, it appears as though there should be a video of the alleged incident. I don't believe I have that. I do have a number of body cams from the actual arrest of my client, or what appears to be the arrest of my client. Quite frankly, I have not had an opportunity to go through all those videos in a 12-hour span, of which I have, but I will have time, Judge, and I'll just be asking for an in-person examination on this matter.
Okay, what date would you like? We need at least 7 days.
I'm sorry, Judge.
We need at least 7. We need
Yeah.
at least 7 days out.
Oh yeah, I'm going to need probably more than the 7, Judge, to make sure I review everything and make sure that I do get the discovery. I would ask somewhere between 14 and 21 days out, Judge.
Okay, pick a date.
And Your Honor, I do have information as to furloughs for the officers that are necessary for this exam.
Okay, Mr. Chambers, pick a date and we'll see where we land.
All right. How is August 12th, if we could do it sometime after 10:30?
So I will be quite frank, the officer in charge is out the entire month of August. However, I don't anticipate him testifying, so we can have a substitute officer in charge. That should be no problem. So the 12th, I believe, should be a good date.
Okay.
There it is.
So August 12th at, you said sometime after 10:30?
Yes, Judge, please.
Okay,
Your Honor,
we'll
I
say-
anticipate up to 4 witnesses.
Okay, we're going to say August 12th at 11 a.m.
Could I get a PCC form on this case?
A PCC form, yes.
Yes.
Okay, in-person exam, August 12th at 11 a.m. And any concerns that you have when you are reviewing the discovery that are jumping out at you, please make sure that you are in contact with the prosecution to hopefully remedy that before the exam date.
I definitely will, Judge. Ms. Bailey, I will get a copy, I assume, of the video, assuming DPD got it.
Yes, I'll relook into all of that.
Okay.
When I say got it, I mean got it from the complainant.
Yeah.
Not has it, either or.
Yes. And I will look into that video, and if it is missing or if it is present, and do all of that we've just talked about. But Your Honor, I do wish to address bond.
Okay, yes.
So, Your Honor, I believe that it is that the bond is currently set at 25, I believe, 10%. There is no GPS tether requirement if the defendant is able to post, Your Honor. Given the seriousness of these allegations in conjunction with the fact that the defendant knows where the complaining witness works, in conjunction with this being a habitual 4th offense notice, with prior convictions of unarmed robbery,
I think that adding a GPS tether is appropriate. It should have been added at the onset. This is a extremely low bond, I think. 25,010 on a lead charge being carjacking.
yes, Your Honor. And I would also request that the 10% provision be removed.
Oh, okay. Well, Mr.
Judge,
Chambers?
yeah, Judge, this isn't your typical carjacking. Now, of course, we all know that he is innocent until proven guilty beyond a reasonable doubt. But even if we imagine that he is guilty of what he's alleged of, when we hear carjacking, that scares us because we think someone's sticking a gun and pulling someone up out of the car or yanking someone out of the car with some sort of physical force. According to the allegations here, that was not this situation. The carjacking elements come in as the complainant who owns some form of car dealership or sells used cars or something, attempted to pull my client allegedly out of the vehicle as my client was driving away from the scene. And my client allegedly hit him, punched him.
And dragged him for 5 or 6 blocks.
And first and foremost, do not interrupt me when I'm in the middle of a conversation. I don't know what you think this is. Now, Judge, that being the case, my client's on parole. That's acknowledged. But in this particular case, Judge, if for whatever reason MDOC lets him out and he posts his bond and he's on tether, I think that does satisfy this situation, Judge. This is not your typical carjacking. What this even alleged to be, and I don't have all that, I am not conceding that my client is guilty of this whatsoever. But what we have here is an alleged larceny or an alleged UDAA that turned into a carjacking because the owner of the vehicle reached in the car, tried to snatch him out of the car because he wanted his car back, understandably. And my client fought him off like, get off me. Now, there may be an argument as to the reason why my client was actually taking this car off the lot. We can get into that later. But, I'll end my argument there, Judge. This isn't your typical carjacking.
Thank you. The motion to amend the bond is granted to the extent that the GPS tether is added. I am not moving the 10%. The 25,000, 10% will remain. Again, GPS tether is a condition that the court is going to impose in the event that Mr. Arnett is able to post that bond. There will be a tether that will be required with a verified address and no contact with the complaining witness. That being said, is there anything further?
Your Honor, I would just reiterate my request for no 10%. Again, this is a very serious allegation and the complaining witness is present on the Zoom call and sustained very serious injuries as a result of this incident.
Okay. I'm hoping that you will speak to him with regards to the GPS tether and what that means in adding that. The defendant will be required to have a GPS tether attached at a verified address, and there should be no contact with the complaining witness. Please call the next case.
Okay.
Good day, all.
When you get a chance, can you let me? Calling parties on Aaron Davis. Recalling case number 21-55801. People versus Aaron Edward Davis. Defendant is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm, less than murder by strangulation. Counts 3 and 4, weapons, felony, firearm. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Gloria Smith, P83353 for the honor. For the people, Your Honor. Good morning. Sorry.
Let's miss it.
Mr. Polk. I
see him.
Back to you.
Okay. That's
You can just call another.
That's it. That's all I have.
What's your name, sir? Felicia, since we have nothing to call, did you want to take a 5-minute break? Okay. When Madam Court Reporter returns, we're going to recall Maldonado as well as Mr. Brown's case. Thank you.
Calling parties on Zayana Patrick. Calling case number 20-60987. People versus Zayana Patrick. Defendant is charged with count 1. Police officer assaulting, resisting, or obstructing. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Good morning, Your Honor. Remind who on behalf of the people.
Good morning, Your Honor. May it please the court, Mark Brown, my P number is 39562, appearing on behalf of Mrs. Ayana Patrick, who's present via Zoom. We have no objection to continuing via Zoom, although I realize this was scheduled for a in-person exam.
Thank you. Please state your name.
Diana Patrick.
Thank you. All right. Today was the date and time, is the date and time set for an examination, set for 10 a.m. It's currently 10:37. What's the status of that, Madam Prosecutor?
Your Honor, at this time, the people are not ready to proceed. Police Officer Kara Colby was subpoenaed and reminded yesterday to appear in court today and has not done so. At this time, the people are not ready to proceed.
Mr. Brown?
I move to dismiss, Your Honor.
Given the representation that has been made by the prosecutor, I am going to grant that motion. The matter is dismissed without prejudice, which means, Ms. Patrick, that it is possible that the prosecutor can reissue. If you have questions regarding that, please make sure that you ask your attorney to explain it to you in greater detail. Do you have on a GPS tether that needs to be removed, Ms. Patrick?
No, ma'am.
Okay. Ms. Brown, do I have permission to sign your name to the
Please
order
do, Your
of
Honor.
this? Okay. I'll make sure that both prosecution and the defense get a copy of this order of dismissal. The matter is dismissed without prejudice. Is there anything further?
No, Your Honor. Thank you very much. Have a great weekend.
You too, thanks. Yes, you can recall. Oh, yeah, because I'm still trying to write something.
Okay. Recalling parties on Ronaldo, calling case number 2159406, People versus Rolando Maldonado.
Appearances again, please.
Jacob Bloomers on behalf of the people.
Neighborhood Defender Services by Ken Reagan, P82125 on behalf of Mr. Rolando Maldonado.
Interpreter Evelyn Villarreal, state certified for Mr. Rolando Maldonado.
Maldonado, please state your name.
Señor Maldonado, por favor, diga su nombre.
Rolando Maldonado.
Rolando Maldonado.
Thank you. Counsel?
Your Honor,
Please,
Your Honor, I have had an opportunity to speak with my client. I'd like to make an application to reduce bond.
Señoría, tuve la oportunidad de hablar con mi cliente y quiero pedir, tener la oportunidad de pedir a la corte una reducción en fianza.
Your Honor, my client currently, obviously, he's been charged with a number of serious charges, the uppermost charge being home invasion first degree.
Su señoría, mi cliente está acusado de varios cargos serios, el más grave siendo invasión de hogar.
His current bond is $150,000 cash with a GPS tether.
Actualmente le han dado una fianza de $150,000 en efectivo y con un dispositivo para monitorearlo.
Your Honor, my client obviously maintains his innocence and says that this is nothing more than a domestic dispute between he and his wife.
Su señoría, obviamente, mi cliente mantiene su inocencia y dice que esto no es nada más que un argumento entre él y su esposa.
As far as a criminal history, my client indicates he has nothing other than he says he may have an OWI incident out of e-course, but no other criminal history.
Con respecto a sus antecedentes penales, mi cliente dice que no tiene antecedentes penales, aparte de quizás una acusación de estar manejando tomado en la ciudad de e-course.
In addition, my client has worked for the same construction company for the past 3 years on highways and has been in the union since 1991.
Aparte de eso, quiero decir que mi cliente tiene empleo, ha estado trabajando por 3 años para una compañía de construcción, trabajando por en los autopistas y ha sido parte de un sindicato desde el 91.
He does have the love and support of his family, his sister. In addition, I'm sorry, go ahead.
Él tiene el amor y el apoyo de su hermana.
In addition, he has a separate address from his wife, his estranged wife, of 1200 Cass Green.
Aparte de eso, él tiene una dirección que es diferente de la dirección de su esposa. Es la dirección de 1200 de la calle Cass Green.
Finally, my client is also a U.S. citizen.
Finalmente, le dejo saber a la corte que mi cliente es un ciudadano de los Estados Unidos.
Your Honor, we find the $150,000 bond to be exceptionally high, and we respectfully ask for a reduction in bond.
Su señoría, nosotros pensamos que una fianza de $150,000 es excesivamente alta y le pedimos a la corte una reducción en la fianza.
Thank you. Prosecution.
¿Y la fiscalía qué dice?
Your Honor, the people would object to any modification of bond at this time.
Su señoría, la fiscalía se opone a cualquier modificación de fianza en este momento.
The defendant is charged with a home invasion leading to a sexual assault. There are 2 counts of CSC2, 2 counts of CSC4.
El acusado lo han acusado de un cargo de invasión de hogar, el cual entonces lo llevó a un cargo de conducta sexual criminal. De hecho, tiene 2 cargos de conducta sexual criminal segundo grado, 2 cargos de conducta sexual criminal en el 4º grado.
These are extremely serious allegations, and I don't think there was any abuse of discretion in setting the bond where it is, which I believe is $150,000 cash surety plus a GPS tether.
Y yo reconozco que las alegaciones son muy serias. Digo que la fianza se debería quedar tal como es de $150,000 en efectivo o pagada por un fiador y que también lo podemos monitorear con un dispositivo.
The defendant and the complaining witness have children in common or formally married. I believe that the bond here is necessary both to protect the community and specifically the complaining witness, and also ensure that the defendant appears in court. Without a DSU, I don't know what kind of out-of-state ties the defendant may have. And again, based on the seriousness of the allegation.
May the interpreter begin to interpret.
Yeah, sorry.
El acusado y la víctima tienen niños en común, fueron casados previamente. Pienso que la fianza tal como está es necesaria para poder proteger no tan solo a la comunidad, sino también a la víctima. I will need Mr. Prosecutor to continue after he said that the bond was necessary to protect the community and the witness.
And well, I think I've made my argument, Judge. Again, the people would object to any modification of the bond at this time.
Bueno, pienso que ya he presentado mi argumento. Repito, su señoría, la fiscalía quiere que la fianza se quede tal como está.
The motion to reduce the bond is denied.
Así que la moción que han presentado para reducir la fianza queda denegada.
Considering the allegations before this court,
y cuando tomamos en cuenta las alegaciones que se han presentado ante esta corte,
I am not comfortable with any reduction in the bond, nor have I heard anything.
Yo no me siento a gusto ninguno con alguna reducción en la fianza, ni tampoco he escuchado algo que me haga cambiar de mente.
We have an exam date of August 17th at 10 a.m.
Tenemos una fecha para la audiencia preliminar fijada para el 17 de agosto a las 10 de la mañana.
And Your Honor, may we still have the DSU and the bond hearing on the DSU?
Yes, sir. We'll set that for July 30th.
Thank you, Your Honor.
Y aún podemos tener una plática con respecto a la fianza y también con el DSU. Sí, también vamos a hablar de eso el 30 de julio. Gracias, su señoría.
Thank you.
Gracias.
See Mr. Fulton back.
Call that one up.
Whatever's in your hand.
Okay. Calling parties on Richard Halliburton. Calling case number 206081, People versus Richard Halliburton. Defendant is charged with count 1, unlawful imprisonment. Count 2, assault with a dangerous weapon, for his assault. Count 3, domestic violence aggravated. Defendant is scheduled today for an examination.
Thank you. Lindsey. Appearances, please.
Jacob Bloomers on behalf of the people.
15 Long Street, appearing on behalf of Mr. Halliburton.
Could you put your P number on the record, please?
Yes, P52993.
Thank you. Please state your name, sir.
Richard Halliburton.
Thank you. Today's the date and time set for preliminary examination, set for 10:30. It's currently 10:48. Mr. Prosecutor?
Your Honor, at this time, the complaining witness, Jalen Cleveland, is not present in the courthouse. They were subpoenaed to be here for 10:30 preliminary examination. Without her present participation, people are unable to go forward at this time.
Judge, I will make a motion to dismiss.
Thank you. All right, so this matter was set again at 10:30. It's 10:48, and the complaining witness has failed to appear according to Mr. Prosecutor, that being Jalen Cleveland, and the motion has been made to dismiss. I'm going to grant that motion as it relates to counts 1 and count 2, the felonies. Count 3 is going to be set for a pretrial before Judge, is it Garrett? Mr. Clerk?
Yes, ma'am, Your Honor.
August 13th?
Yes, ma'am.
And I do believe in reviewing this that Mr. Halliburton is on a GPS tether.
Yes, Your Honor. That's, I would ask that the tether be removed. I would tell the court that, from my understanding, there have been no communications, no violation of the tether. I understand that the court has pre-trialed the trailing misdemeanor. However, I will also tell the court that this case came into our office through community insight. Mr. Halliburton learned that there was a warrant for his arrest. He worked with our office to turn himself in and has been abiding by the terms of his pre-trial release since, I believe it was October of last year.
Okay.
So Judge, I'm asking that you remove the tether.
Mr. Prosecutor?
Your Honor, I guess I would object to the tether. I know that the felony here has been dismissed. However, there is still an aggravated domestic violence count. And given that charge, I would choose that the tether remain in place.
Count 3 that remains, again, that misdemeanor domestic violence aggravated, wherein the complaining witness, the allegation is that a weapon was, I'm sorry, no weapon, without a weapon, but the infliction of serious or aggravated injury. Again, I understand that's the allegation, but that's what I have to look at when I'm reviewing the bond. Notwithstanding the fact that the felonies have now been dismissed. On this tether violation, what became of that?
Judge, if the court will recall, that's a tether violation where Mr. Halliburton was taken into custody. The police were called to his home, and because he was on tether, they arrested him. His cousin is someone who I believe attacked him. If the court, I know the court won't remember, but he appeared on Zoom with some severe facial injuries, and there was no warrant or any other further action taken. It was totally unrelated to this case or to the individuals in this case.
I'm gonna leave the tether in place. On August 13th, you can certainly make that application to the presiding judge. I believe it's going to be Judge Garrett, with regards to removal of the tether.
Okay, thank you.
Oh, I just need your signature on this order of dismissal as the moving party. Counts 1 and 2 are dismissed without prejudice again.
Do we have Anthony Gray at Division 1?
Yes, this is him.
Okay. Calling parties on Anthony Gray. Calling case number 21-59457. People versus Anthony Allen Gray, AKA Dwayne Ivan Gray. Defendant is charged for count 1, assault with intent to do great bodily harm, less than murder by strangulation. Count 2, domestic violence. Defendant is a habitual offender. Second offense notice. Defendant is scheduled today for a probable cause count.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Ms. Bates, it's Ms. Bates. I see her. Okay. Can you send up Mr. Bates? Calling parties on Aaron Davis. Recalling case number 21-55801. People versus Aaron Edward Davis. Defendant is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm, less than murder by strangulation. Counts 3 and 4, weapons, felony, firearm. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Lord Morales Smith, P83353 for the people, Your Honor.
Please, this honorable court, Larry spoke on behalf of Mr. Davis, standing in for the attorney of record, Lillian Diallo. Mr. Davis is present, I believe, in the courtroom. My P number is 48164.
Thank you. Please state your name.
Aaron Davis.
Thank you. So today is the date and time set for preliminary examination. I do understand that Ms. Diallo is not able to come into the court today. Is that true? Mr. Polk?
That is correct, Judge. Are the people ready to proceed?
Yes, Your Honor, the people are ready to proceed.
Mr. Polk?
I heard him, Judge. So, you know, I called in earlier. Ms. Diallo asked me if I could cover this matter. She's asking for an adjournment based upon her inability.
Okay. How much time would she need?
She's requesting 3 weeks, Judge.
So the defendant, Mr. Davis, is out on bond. So my concern is not as it would be with an in custody matter in terms of timing. What date would?
I'm sorry, Judge. It seems like the sound went out.
Oh, okay. So October, the first week in October?
That's fine, Judge.
Can you assign the date?
You see, the first week
in
of
October, please.
Okay. 1 second, Frank.
How many witnesses for the prosecution?
2 or 3. Probably just 2.
How about October 8th at 9:30?
October 8th at 9:30, Mr. Polk?
That's fine, Judge.
Okay. New in-person examination, October 8th at 9:30.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
You're welcome.
Recalling parties on Anthony Gray. Recalling case number 21-59457. People versus Anthony Allen Gray, AKA Dwayne Ivan Gray. Defendant is charged with count 1, assault with intent to do great bodily harm, less than murder by strangulation. Count 2, domestic violence. Defendant is a habitual offender. Second offense notice. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
And good morning, Your Honor. Melanie Bates, appearing on behalf of Mr. Anthony Gray, who I believe is in the county jail and present by Zoom.
Okay, please state your name. Please state your name.
Anthony.
Counsel, what's your pleasure?
Your Honor, I'd like to set this matter for a preliminary examination.
Any discovery concerns?
It looks like I just received some paper discovery today. I'm not sure if there is any digital discovery. Mr. Bloomers, could you speak to that if there is?
I can't speak to it right now, but certainly I will follow up with it.
Okay, fair enough.
You want to pick a date?
Let's see.
The week of August 2nd would probably be the earliest. Actually, yeah, the week of August 2nd, week of August 9th. Jammed up, but your client is in custody, so.
Judge, how about August the 6th?
August 6th, 10 a.m.
What time was that, Your Honor?
10 a.m.
10 a.m. And Your Honor, I did not get a chance to have a video visit with Mr. Gray. Everything was full. I won't be able to have one until next week, and I'll have to host it myself. But I still wanted to address his bond. I'm not sure if I can go into a breakout room with him, or if you would like me to just, after I meet with him, schedule a bond motion.
It's up to you. Do you want to go into a breakout room?
That would be great, Your Honor.
Is that Mr. Walker? Do we have Mr. Walker over at Wayne County Jail? Is that Dominique Walker?
Dominique Walker should be out. It shows he's on personal bond.
Yes, I'm here.
Calling parties on Dominique Walker. Calling case number 21-59570, People versus Dominique Jonte Walker. Defendant is charged with count 1, stolen property, receiving and concealing $20,000 or more. Count 2, police officer fleeing, 3rd-degree vehicle code. Count 3, police officer assaulting, resisting, or obstructing. Defendant is a habitual offender. Second offense notice. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Slusky on behalf of the people, P83677.
Good morning, Your Honor. For the record, Sterling Coleman on behalf of Mr. Walker. I'm standing in for his assigned counsel of record, Sanford Schulman. Judge, it looks like I'm sorry.
Mr. Walker, can you state your name, sir?
Dominique Walker.
Thank you. Mr. Coleman?
Judge, it looks like from Mr. Schulman is actually in a federal proffer, for lack of a better way of saying it. So he wasn't available today. However, it looks like he has not received discovery. So we're going to ask for another PCC. We can get it and try to figure this out. But he needs discovery to otherwise.
July 30th at 8:30 via Zoom.
I'm sorry.
July 30th at 8:30 via Zoom.
I'll indicate that to Mr. Schulman. I'll give notice to Mr. Schulman. Hopefully we'll have discovery before then so we can advise the client and proceed.
Mr. Slusky, can you make discovery gets over straight away?
Of course, paper discovery has already been uploaded, so I can send that today. I don't have video yet. I will be requesting that and get that sent out to you as soon as I can. I believe I should be able to do that within the next week. And so hopefully by the next PCC, I should have complete discovery tendered and we can go from there.
Which will be Friday, the 30th at 8:30.
Okay, thank you so much.
Thank
Mr.
you again.
Banter,
Stay safe.
you too.
Please stay. Calling parties on Tamarian Brazel. Calling case number 20-62477. People versus Tamarian Tion Brazel. Defendant is charged with count 1, controlled substance, possession of methamphetamines or ecstasy. Count 2, weapons, firearms possession by felon. Count 3, weapons, ammunition possession by felon. Count 4, carrying a concealed weapon. Counts 5, 6, and 7, weapons, felony, firearms. Defendant is a habitual offender. Third offense notice. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Good morning, Your Honor. Remax Luke on behalf of the people.
Good morning, Your Honor. Richard Bant on behalf of Tamari and Brazel. Mr. Brazel should be present in the courtroom.
Please state your name.
Mario Basil.
Thank you. Today is the date and time set for an examination. Are we proceeding to an exam?
Your Honor, at this time, the people are not ready to proceed. Both police officers, Webb and Funchess, were subpoenaed and notified to be in court today and have not showed up.
Is there a motion? I have some,
Motion.
I need a stack of orders of dismissal. Is there a motion?
We ask that the case be dismissed, Your Honor.
It is currently 11:03. This matter is set for 9:30 examination, and given the representations that have been made, I am going to grant that motion to dismiss. The matter is hereby dismissed without prejudice.
Thank you, Your Honor.
Do you have on the GPS tether that needs to be removed?
No, ma'am.
Okay, so if you have a seat in the hallway, we're going to bring that paperwork to you regarding the dismissal, okay? If you have questions regarding what dismissal without prejudice means, in essence, means prosecution. If you have questions about that, which I would imagine you may, please make sure you speak to your attorney and he will explain the fullness of that concept to you, okay?
Okay.
Yes.
They called from downstairs and felony, right? They said we do agree for personal violence.
Sure.
Can you call back in 10 minutes? That's it.
recalling Gray. Appearances, please.
Jacob Bloomers on behalf of the people.
And good morning again, Your Honor. Melanie Bates on behalf of Mr. Gray.
Mr. Gray, please state your name.
Anthony Gray.
What's your pleasure, counsel?
Thank you, Your Honor, for giving us the opportunity to speak. I would like to address Mr. Gray's bond. Currently, it is a $20,000 10% bond. I'm asking for a reduction as Mr. Gray does have financial hardship. He was just in the hospital last night at receiving because he does have heart disease. He has a pacemaker on, and he has had many of the EKGs that's telling the hospitals, and all of his medical records show that he has this serious heart disease, and he's 54 years old. So the jail is not the best place for him right now, although we do understand the circumstances of the case, Your Honor. In addition, he is a licensed electrician, and he's been doing that for over 30 years. And for the past 7 years, he has been self-employed. It's kind of been lucrative, but not as lucrative, Your Honor. That's one of the reasons he cannot meet his bond. So we're asking for a reduction in bond, hopefully a personal. If not, then maybe a 10,000, 10%. And he understands that this honorable court would likely order a GPS tether. He would be living with his daughter. Her name is Brandy, and she lives in the city of Detroit, and he understands absolutely to have no contact with the complainant in this case.
Mr. Prosecutor?
Yeah, I've had a chance to review the bond and the investigator's report. I believe the bond is currently 20,000, 10% with a no contact order, no tether order. I heard defense suggest a 10,000, 10% with the GPS tether, and I'd be willing to stipulate for that.
10,000, 10%?
With the GPS tether.
Okay. Can I have a bond reduction? Given the posture of the prosecution, I will grant that motion to reduce the bond to $10,000 cash or surety with the 10% provision with the GPS tether and no contact with the complaining witness.
Thank you very much, Your Honor. Thank you very much, Mr. Bloomers.
We will see you at the exam date.
Okay, thank you very much. And Mr. Gray, I will be in touch with your daughter. Okay? Okay, everyone have a good day.
You too.
You too.
Mr. Cooper just called and said he'll be here in 20 minutes.
I guess I'm gonna go back across the street and we'll see if Mr. Wazak is in at any point here. I don't have a witness on Thomas.
Mr. Sanders, can you
Calling parties on George Thomas. Calling case number 2059201, People versus George Thomas. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony firearm. Count 3, domestic violence. Defendant is scheduled today for an examination.
Appearances, please.
Jacob Bloomers on behalf.
Good morning, Your Honor. Daniel Wozak, P35225 on behalf of Mr. Thomas. Your Honor, my apologies. Apparently, when he was arraigned on the bench warrant, they set this date, and I was not advised of it.
Okay. Today is the date and time set for preliminary examination. Have we received a phone call from Mr. Thomas?
No, ma'am, Your Honor.
Have you had any communication with Mr. Thomas, Mr. Wozak?
No, Judge. In fact, following his capias, which I believe was on June 24, on June 24, I called the client, and on June 30, I emailed the client, and I've had no response.
Yes, Your Honor, and I would just, I think Mr. Wozak pointed out already, but he was previously capious on the 24th. It looks like at the arraignment on that previous capious, a tether was ordered, so hopefully we can find him, but people move for a capious again.
Yes, it does. Mr. Clerk, I will ask you to notify the tenant in this matter. As a capious is, I am going to grant that, capious will issue, and unless he's detached it, they will be picking him up. The previous bond is revoked. The new bond is going to be set at $25,000 cash or surety. With GPS tether. Is there anything further?
Nothing from the people, Judge.
Nothing further from defense, Judge.
But Mr. Wozak,
Yes, Judge.
this is a gentleman, you're saying capious, this is his second time?
Yes, Judge.
Yes, Judge.
Wow.
It looks like he was capious on the 24th. They arraigned him on the 12th and just reinstated his bond with a tether.
I'm going to actually raise the new bond. His new bond is going to be $50,000 cash or surety with GPS tether.
Understood, Your Honor. I will continue to try and reach him. But if he's on tether now, they should be able to find him.
Okay, we're all set here. Thank you.
Thank you, Judge.
Everyone have a great weekend.
You
You too. Thank you. Hey, how you doing? He can't do this on his exam, but he's listed as being on the tether.
I've been waiting all day.
Client called. If you could get him on Zoom, I can ask, Ms. Yafufi maybe to stand in for Mr. Bloomers on a dismissal.
Okay.
Okay, if you can get your client, Mr. Wozak, I'm hoping you can hear me. Thank
I
you.
can hear you, Judge, and he is supposed to be zooming in as we speak. He responded to the, I called the bail bonds company and we tracked him down.
Hold on 1 second.
Yeah, that's fine.
Okay.
She's on Zoom.
She's on Zoom.
The defense attorney's on Zoom.
Okay.
Excuse me, Judge. Mr. Thomas, you need to stand still with your telephone and hold it steady. Don't walk around, all right?
Whatever you want to call.
Are we ready on
Patterson?
Patterson?
Did you talk to Mr. Bloomers on Thomas?
I did, I sent him a message, I'm just waiting for it to respond.
Oh, okay.
You said Mr. Bosman is on Zoom?
Miss Woodside, she's representing Mr. Patterson. who's
Oh,
in the
Miss
courtroom.
Woodside? Okay. Patterson?
You're Patterson, right? Your attorney's on Zoom.
Can you stand, Mr. Patterson?
My attorney here involved.
I don't know, my file says, Ms. Woodside.
I have a paid attorney here involved. He's supposed
Is
to
he
be.
here?
Yeah, he's supposed to be here, yes.
Okay.
Okay. All right, you can have a seat. We'll wait here.
Can I step on the podium and see what's going on? Absolutely, go ahead, sir. Here you go.
Okay. Are you on Willis George too?
No.
It's a nice question.
Oh. Okay. We're ready.
We're in there. You can stand up.
Calling parties on Javen, Alonzo, Woods George. Calling case number 20-57010. People versus Javen, Alonzo, Woods George, AKA Javen, Alonzo Woods. Defendant is charged with 1 count, reckless driving causing death, commission of a felony with a motor vehicle advisory. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Good morning, Your Honor. Jonathan Lysak, P 74620 on behalf of the people.
And good morning, Judge. Renee Cooper on behalf of Mr. David Woods George.
Good morning, Mr. Cooper. And Mr. George, could you please state your name, sir?
Kevin Williams George.
Thank you. Today being the date and time set for a preliminary examination, are we proceeding to?
Judge, when Mr. George and I first met, I didn't have the video yet. I have it. He looked at it. He no longer wishes to have an exam, so he has signed the appropriate waiver of examination form.
Okay, is there any objection to the proposed waiver?
No, Your Honor.
Thank you. Mr. Woods George, I just need to ask you a few questions, okay?
Yes, ma'am.
Do you understand the allegations against you, sir?
Yes, ma'am.
Do you understand that you have a right to a preliminary examination?
Yes, ma'am.
Do you understand that if an examination did occur here today, that the burden on the prosecutor would be to establish by probable cause standard crimes were committed, City of Detroit, County of Wayne, and that you probably committed that crime? Do you understand that?
Yes, ma'am.
And if the prosecutor were able to meet that burden, the matter would then be bound over to the circuit court for further proceedings. Do you understand that process, sir?
Yes, ma'am.
So the representation has been made that you wish to waive, to give up your right to a preliminary examination. Is that true?
Yes, ma'am.
And do you understand that that would mean, if your waiver is accepted, that the matter is automatically bound over to the circuit court for further proceedings without the benefit of an exam at this phase? Is that how you wish to proceed? Mr. George Thomas, can you please mute your microphone?
Yes.
Thank you. Is that still how you wish to proceed, sir?
Yes, ma'am.
Thank you. And are you doing so voluntarily?
Yes.
Thank you. I do have the examination waiver form returned to the file here that is properly executed by both defense counsel and the defendant. I do find your waiver to be voluntarily given and knowingly given. I am going to bind the matter over to the circuit court for further proceedings with an AOI date of August 13th. August 13th. At 9 a.m. Is there anything further?
No, not from the defense, Judge.
I only put on the record, Your Honor, that all our police officers that were subpoenaed did in fact appear, ready to go. And ultimately, I'm very pleased that they did show. So,
Awesome.
thank you, Your Honor.
Thank you so much. Okay, we're all set here. Thank you so much. Good to see you,
Thank you.
Mr.
Good
Cooper.
to see you, or at least half of you, Judge.
Yeah, right. It's been a long time since I've seen you.
Take care.
Take care, sir. I thought I saw.
Calling parties are Richard Patterson. Calling case number 20-56908, people versus Richard Adrian Patterson, AKA Richard Adrian Patterson II. Defendant is charged with 1 count, carrying a concealed weapon. Defendant is scheduled today for an examination.
Thank you so much. Appearances, please.
Good morning, Your Honor. Rima Hook on behalf of the people.
May it please the court, Harry Hoffman, P 55052 on behalf of the defendant, who prepared to move forward with the exam, Your Honor. I do not know if you are ready to proceed. If not, we're asking you to consider a motion to dismiss without prejudice. Thank you.
Your Honor, at this time, the people are not ready to proceed. Police officers have been subpoenaed and notified to show up to court and have not done so.
Okay, it is currently 11:38 in the morning. This matter was set for an exam at, I think, was it 11?
11:30, Your Honor.
Oh, at 11:30. And the prosecution is unable to proceed. I am going to grant that motion. Oh, I'm sorry, did you make the motion? I'm sorry.
I did.
Okay,
So
the
moved.
motion is going to be granted to dismiss this matter. The matter is hereby dismissed without prejudice, which means, sir, and I don't know if I had you put your name on the record. Could you state your name, sir?
Richard Patterson.
Thank you. The matter is dismissed, but it's dismissed without prejudice. So what that means, Mr. Patterson, is that, thank you. What that means, Mr. Patterson, is that it is possible that this can be reissued. That normally causes people some confusion. If that is a confusing concept, that this could possibly be reissued, please make sure you have a separate conversation with your attorney and he will explain it to you, okay?
You say it can be possible?
It is possible that it can be reissued. And I always like to explain that. That's what that trailer language after the word dismissal without prejudice means. So just make sure you have a conversation with your attorney and he'll explain it to you in greater detail, okay?
Okay.
All right. Do you have on a GPS tether that needs to be removed, sir?
No.
Okay. I just need your signature, Mr. Defense Counsel, Mr. Hoffman, on this order of dismissal as the moving party. I'm preparing it right now. And is there anything further?
Nothing further from the defendant, Your Honor. Thank you.
None from the people, Your Honor.
All right. We're back, Mr. Bloomers.
He said he'll be on in 2 minutes.
Oh, great. Thank you, Ms. Yafufi.
Thank you.
That is teamwork. You too. Have a good weekend.
I'll see you on Tuesday.
Yes. Okay, here he is right here.
Hey, how are you doing?
Mr. Hoffman, it's good to see you.
Good to see you as well, Your Honor. Feel like a duck out of water.
Yeah. And Mr. Bloomers is here, Mr. Wozniak.
It was earlier, it's completely dry now.
All parties are here on George Thomas.
Okay. Calling parties on George Thomas. Calling case number 20-59201, People versus George Thomas. Defendant is charged with count 1, assault with a dangerous weapon. Felonious assault. Count 2, weapons from the firearm. Count 3, domestic violence. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Daniel Wozniak, P35225 on behalf of Mr. Thomas. He is appearing via Zoom, waiving court present.
Okay, Mr. Thomas, please state, if you could have your video rolling and please state your name.
Hello,
Yes, if you could state your name, sir.
George Thomas.
Thank
Morning.
you. Oh, good morning to you. Thank you for zooming in, sir, because what happened earlier is that we called your case and you weren't here, and the prosecution moved for a warrant to be issued because you didn't show. So I'm glad you're here. I'm going to set that capias aside.
Thank you.
And the fact that you are here in Zoom gallery is the good faith showing to me. With that being said, had you been here in person, Mr. Prosecutor, would you have been able to proceed to an examination here today?
Your Honor, this case was set for a 9 a.m. preliminary exam. The complaining witness was subpoenaed to be here at that time. They did not appear in the courthouse. The people would not have been able to proceed on counts 1 or 2.
Mr. Wozniak, is there a motion?
Yes, Judge, at this point, I would move to dismiss counts 1 and 2. In light of the fact that it is the same complaining witness for count 3, I'd ask that count 3 be dismissed also.
Thank you. Counts 1 and 2 are going to be dismissed without prejudice, as they are felonies. Count 3 is going to be set for a pretrial before Judge Garrett on August 13th. So the dismissal is as it relates to count 1 and 2. Just
So I have a question.
Well, first of all, I can't hear you, so wherever you are, please get somewhere where there is not a lot of background noise.
Okay.
Number two, notwithstanding the fact that the complaining witness is the same, Judge Garrett has jurisdiction over the misdemeanor. Is this a question for me or your attorney?
For you, I was trying to see what been dismissed? What charges?
So which ones were dismissed? Count one, assault with a dangerous weapon, felonious assault, the first felony. Count two, weapon, felony firearm, the second felony. So the two felonies have been dismissed without prejudice. Now, let me just, as an aside, indicate to you that when a matter is dismissed without prejudice, what that language means is that it is possible that the prosecutor can reissue. I would ask that you have a separate conversation with your attorney so that he can explain the fullness of that concept. The remaining count is the misdemeanor, the domestic violence count. That matter is going to be set for a pretrial before Judge Garrett. That's going to be on August 13th.
Okay.
At presumably, is it 8:30 or?
8:30.
At 8:30. Mr. Wazak, do I have permission to sign your name to the order of dismissal as the moving party?
Yes, Judge, you absolutely do.
And we're going to forward a copy of this dismissal to you in short form.
Thank you, Judge.
Is there anything further?
Nothing from defense, Judge.
Nothing from the people, Judge.
Okay, please make sure you continue that no contact with the complaining witness.
Okay.
Yes, Judge, I'm going to telephone my client immediately after the meeting. Thank you.
Thank you.
Is it? I don't know if you eat any bacon, then you have.
I'm gonna take another pill.
Please silence your microphone.
You take all that medication, either.
No,
Your Honor, I was hoping to see if we could check in on John Dawson.
Ms. Burton never logged back in, Your Honor.
Okay, maybe check back in at 1:30. The court is getting ready to stand in recess for lunch, as we have not heard from Ms. Burton. And I think we'll see you at 1:30, so.
You will. And I sent you my response directly to you. I understand there's some way to submit motions to the 36th district, but I'm not really sure how that works. So I thought I'd cut out the middleman and send it directly to you.
That'd be great.
You want me to do it again? Because I did it earlier this week. Just for convenience, if you want it.
Mr. Sanders, that'd be great. He
Sorry?
can print it out. If you could forward it via email to Mr. Antel Sanders, and he can print it out and hand it directly to me.
Okay, great. I'll do that right now.
I can look. Let me check.
Okay, if you could let Ms. Burton know, maybe leave a message to let her know that she should zoom in at 1:30. The court is recess until 1:30.
Okay.
Your Honor, we'll see you after lunch.
See you after lunch, sir.
Oh, let me check now, please.
Oh, yeah, is that gonna be all rooms? Somebody coming in.
That's on Zoom. It's via Zoom.
Okay.
Motion, John Zoom?
Yep.
Oh, okay.
So we'll see y'all tomorrow.
Monday.
I mean, Monday, yeah. Okay.
Let's see you next time.
Y'all have a good weekend.
All right.
You too. County Judge?
No, go ahead, go ahead.
Okay, all right.
Oh, thank you. What is that?
With Mr. Bloomer.
Oh.
I mean, Mr. Slus.
Mr. Susky.
This baby said, the date for Arnett is not good for her complaint witnesses.
So she'll zoom in.
When should I have them zoom in?
Who's the opposing counsel?
That's Mr. Chambers.
If they can zoom in at 1:30, if not, Monday's fine.
You have reached the law offices of David Steingold, Pamela Saucy, and Arnie Chambers. One is available to take your call right now, but if you'd like to leave a message for David Steingold, please press 1, or you can reach him on his cell phone at 248-802-7515. To leave a message for Pamela Saucy, press 2, for Arnie Chambers, press 3, or for Samantha Baker, press 4.
Hi, Mr. Chambers, this is Antel from the Doctor's Courtroom. Hi, Mr. Chambers, this is Antel from the Doctor's Courtroom. Hi, Mr. Chambers, this is Antel from the Doctor's Courtroom. Can you give me a call back at 313-965-2282? It's in reference to your patient this morning from Mr.
Okay.
Can you turn the recorders off?
Oh, yeah. So this 1:30 is gonna be interesting.
Is it?
Yeah. It's, yeah, you'll see.
Okay.
So, what I was saying about this.
Oh, mute us.